Okay, welcome to this recording where I'm presenting some updates to the administrative law material, specifically regarding two recent cases dealing with what we call or what the U.S. Supreme Court is calling a major question and a alteration of a previous precedent known as Chevron or the Chevron doctrine, which is discussed in the course materials or earlier videos if you're looking at this sequentially. So the two cases that we're talking about here are West Virginia versus EPA, the 2022 case, and then Loper v. Raimondo, a 2024 case. In both of these cases, the U.S. Supreme Court made distinctions between both current precedent and pre-existing sort of legal doctrine regarding the extent of agency discretion, how far agencies can go when they interpret the statutory delegation of authority that they've received from Congress in a particular statute. So we'll just talk about that and put it into context. By way of review, the following material has been presented previously. We can look at sort of statutory delegation and agency power relative to that statutory delegation in the following way. We can sort of see a spectrum here, and the spectrum shows the amount of authority capable of being granted by Congress, sort of this long black line here, and there are ends to it on both sides of the spectrum. Anything that happens outside of that spectrum is beyond the authority. So it's beyond the authority Congress has. So in this case, we're suggesting here that the black line represents all of the authority Congress has under its legislative authority. Think of Article 1 of the U.S. Constitution, right? Legislative authority, all of the power that Congress has to pass legislation, any and all powers. That power begins and ends somewhere because we have a separation of powers doctrine here in the United States. Article 2 leads to the executive power, and Article 3 leads to the judicial power. And so Congress can't do things that are wholly reserved to the executive, and it can't do things that are wholly reserved to the judiciary. It has limited power. But the black line is meant to represent all of the power that Congress has. And then there's this conceptual sort of beyond authority, this where Congress could not grant the authority to do this because it has no power to do so. So it couldn't grant an agency, for example, powers it did not have to grant. So we can then look at this sort of this green spectrum within Congress's black power or authority to grant or to delegate power to the executive branch, administrative agencies in our case, at least at the federal level. And we can see this green line to represent the actual authority granted by Congress in a particular statute. So here, deal mostly with environmental law. So we talk about, like, for example, the Clean Air Act or the Clean Water Act, some federal environmental law. Within that federal law, there's amount of authority that Congress has taken. Congress has expressed some authority, and we assume that authority that Congress has expressed within that statute is within its power. It's within the black lines. But that authority is not all things that Congress can do, and it's expressing some form of that authority. Go and do something regarding the air. Go and do something regarding the water. And when it says go and do something, there's, the federal law is to take some action, and it usually relies on executive agencies in order to implement that will, to take the actual action. So if the green line represents, the authority that actually is granted to, let's say, an executive agency under the executive branch at the federal level, then the red line represents authority that's withheld from that agency by Congress in that particular statute. If the statute doesn't speak to it and there's not a reasonable interpretation of it, then it's outside. So we always say that this green area represents the agency action within the delegation, what was provided to Congress, and that the red represents the agency action outside of a delegation of a particular statute, what Congress did not provide to the agency. Now, previously, we've discussed this where we've talked about Chevron and Chevron providing this sort of interpretive analysis by the U.S. Supreme Court. And Chevron deference usually meant that even when the statute is not explicit on a particular topic, if the statute is silent, but what the agency is doing is a reasonable interpretation of what the statute seems to intend, then the judiciary historically has deferred to the agency and said that, well, that's a reasonable interpretation of what Congress wanted you to do, so your exercise of power is within the green area. So this has changed now to some degree. If we assumed previously that all of this green line was, for example, Chevron provided all of this green area. What these two new cases have done, very likely, is they've limited the effect of how far an agency can go in interpreting the will of Congress when it's attempting to do what it's meant to do, for example, to, implement the goals of the Clean Air Act or implement the goals of the Clean Water Act. So we have this one area, we're going to call this reduced green area, the explicit. So if the statute is explicit, so for example, in the Clean Air Act, it literally lists what we call criteria pollutants, certain things that the statute identifies clearly and explicitly as a pollutant, as an air pollutant. For, let's say, the Environmental Protection Agency as the federal agency, for the Environmental Protection Agency to actually develop rules about regulating to determine what's a safe amount of these particular criteria pollutants, what's an unsafe amount, and then to go out and actually enforce whatever those rules are developed to make sure that there's not too much of this bad stuff in the air. Let's call it, sometimes it's sulfur, you think of acid rain, there's particulate matter, there's a number in the statute, a number of these criteria pollutants. And those are considered explicit. They would be explicit. So it's no problem for the EPA to try to regulate sulfur or certain particulate matter because they're explicitly identified under the Clean Air Act. So under, for example, the Loper decision, Loper v. Raimondo 2024, the U.S. Supreme Court said that, the authority of the executive when it's trying to follow congressional intent is for sure limited to the explicit statements of Congress. So what I just gave you was an example under the Clean Air Act where the Environmental Protection Agency would have clear authority because it's explicitly stated. It used to be there was this area here where we'll just call this Chevron deference, where maybe the Clean Air Act did not identify explicitly specific areas of, let's call them pollutants or things you want to call pollutants or even define as a pollutant. But, the Environmental Protection Agency moved to regulate these additional things as clearly, like as science evolved, for example, as clearly related to the kind of pollutants the Clean Air Act is intended to protect against, human health, that kind of thing. So maybe there's a pollutant that's identified by the Environmental Protection Agency that is not explicitly stated in the Clean Air Act, but it's clearly the kind of thing that Congress intended to be regulated under the Clean Air Act. Well, under Chevron, if the Environmental Protection Agency, the executive agency, had moved to regulate this additional pollutant, maybe under traditional historical Chevron deference, the analysis would have been something like, well, it's okay for the Environmental Protection Agency to do this because even though it's not explicitly stated, it's implicit within the statute. It's a reasonable interpretation that Congress, the legislature, wanted the Environmental Protection Agency, the executive branch, to move further in this direction. It's enveloped within the sort of, overarching purposes of the legislation, even if that particular pollutant is not included in the legislation. That was Chevron historically. Now, under Loper v. Raimondo, to be determined, of course, this will take probably decades for it to work out, but under the most recent precedent, the court stated that the agency is limited to explicit representations from Congress, that Congress has to state explicitly and has to follow much more closely the statute. So let's say that the implicit aspects of an interpretation, what I just mentioned, if there's a pollutant out there, that is not explicitly stated in the Clean Air Act, for example, and it's just a reasonable interpretation. It's likely that if the EPA wanted to regulate that additional pollutant today after Loper, it's more likely that the US Supreme Court would say that that's outside of, that moves now the agency action to show here in the red, the agency action is outside the delegation. So any implicit sort of that would be a possible interpretation, probably a reasonable interpretation of what Loper probably will do. Now, one of the reasons we can say this is because this other case, West Virginia v. EPA in 2022, talked about something called major questions. And when they were talking about major questions, putting Chevron aside, what they were saying is that, look, an agency cannot take an action where it covers an entire field, so much so that it basically turns its authority it now has a plenary, what we would call total authority over a particular area, and it has serious and fundamental economic consequences for the country as a whole. The best example that I can give is it's actually West Virginia versus EPA, the 2022 decision, is EPA trying to regulate carbon. And it tried to do this, and it tried to add carbon as a pollutant for a variety of reasons, because it is related to human health, but clearly carbon because of its effects regarding climate change, the movement of carbon from stored areas into the atmosphere by human action. So the EPA wanted to add carbon to the Clean Air Act as an additional sort of, let's call it a pollutant, just what I was explaining before. And effectively, the US Supreme Court said if EPA was allowed to add carbon and regulate carbon, it now, the Environmental Protection Agency, would touch upon every aspect of the US economy. Carbon is everywhere. And so the EPA would grab a level of sort of authority and jurisdiction under this one federal statute that very likely would have implications that Congress never intended. That's what they mean by major question. So what the US Supreme Court meant in that case is the EPA cannot do that. It's not a reasonable interpretation of the Clean Air Act to say we're going to include carbon. More clearly, it's not a reasonable interpretation because it's implicit under the Loper v. Raimondo decision. But in addition, it has such serious economic impacts and consequences under the West Virginia v. EPA earlier decision that if the EPA wants to regulate carbon, it has to go to Congress and it has to ask Congress to specifically pass an amendment, let's say, in this case, to the Clean Air Act that says, yes, carbon is a new criteria pollutant. We understand that, and we intend for it to be added to the Clean Air Act. And we also intend for the EPA to specifically come up with rules and regulations and enforcement mechanisms to regulate carbon in the United States. They'd have to be explicit. So Congress would have to amend or create a new law, amend the existing Clean Air Act, or create an entire new statute in order for the EPA to have jurisdiction. Then, if they did so, that would be explicit now under the statute. For our example, carbon here would be explicit under the Clean Air Act. And because it's explicit, it no longer violates the Loper v. Raimondo. What we're going to assume is a reasonable interpretation of that case, which it doesn't violate the implicit nature that go too far because you're implicit. Again, Chevron allowed this to happen in the past, but Loper says no more. And in addition, it is a major question for sure, carbon, but correctly, Congress has acted on that major question. And all that West Virginia v. EPA, all that the Supreme Court said there was, if it has this effect, if a agency rule, proposed rule has this effect, it must get explicit authorization from Congress. It can't go alone. It has to get legislative authority, Article 1, go back to Congress, go to the legislature. So that basically is the difference. What I'm saying is that in our earlier, we can see all of this under sort of like a Chevron analysis under our earlier work. And the big difference between these two cases is this really, is this idea that we're now limiting what is an agency action within its delegated authority. Congress has the power to delegate. Congress can cover this area. Congress can make laws. It's within the black. But now we have a distinction where these two cases combined make explicit statements by Congress within the authority for sure, but have removed what previously was probably okay for agencies to do by saying that if it's implicit, then the agency is likely in violation of its delegation authority from Congress. The best thing that the agency can do is to go to Congress. If it wants to regulate something like carbon, for example, it go to Congress and get explicit authorization for two reasons. One, because explicit authorization means that it's meeting the specific requirements of the statute. That's Raimondo, Loper v. Raimondo. And in addition, if something like, regulating carbon results in such a significant economic impact, it becomes a major question and Congress really has to speak to it. So in both cases, better off going to Congress and getting explicit authorization. So that's it. That's the major question as far as we know it to be. And yeah, that's about that for that. Thank you.